The first legal hurdle to implementing affirmative action for education in India came in the form of a case by a Brahmin student who felt that she had been unfairly denied a seat in a government medical college only because she was born a Brahmin. She filed a case before the High Court of Judicature at Madras against what was referred to as the Communal GO of the state of Madras. This was a government order passed in 1927 which provided for the reservation of seats on the basis of community for the medical and engineering colleges maintained by the state. In the 4 medical colleges run by the state of Madras, there were 330 seats. Of these, 17 are reserved for students coming from outside the state and 12 are reserved for discretionary allotment by the state. This leaves 301 seats that the aspiring students within the state have to compete for. The communal GO mandates that the seats were to be divided in the following ratio. For every 14 seats, 6 would go to the non-Brahmin Hindus, 2 to the Hindus classified as backward, 2 to the Brahmins, 2 to the Harijans, which refers to the scheduled castes and the scheduled tribes, 1 to Anglo-Indians and Indian Christians, and 1 to a Muslim. A student by the name of Champakam Durarajan, belonging to the Brahmin community, who had not applied for a seat in a medical college, nonetheless approached the High Court, contending that she had been unfairly discriminated against by the GO. The court was of the opinion that while Article 16(4) of the Constitution of India makes an exception for reservation of seats in employment, there are no similar constitutional provisions for education. So, the GO was found to be in violation of Article 29(2) of the Constitution. When the case came up for appeal before the Supreme Court of India, the highest court in the country was of the same opinion and dismissed the appeal. The Government of India reacted by adding a 4th clause to Article 15 through the First Amendment, which allowed for making special provisions for the advancement of any socially and educationally backward classes, and the way was paved for the modern system of reservations in education that exists now. In the judgment of the Supreme Court, it is recorded that Champakam Durarajan states that on inquiry she came to know that she would not be admitted to the college as she belonged to the Brahmin community. This is far from the truth. According to the census of 1951, there were 14,103 Brahmins in the Madras state. In the same census, the entire population of Madras state is recorded as 3,57,34,489. So, there are 3,43,34,386 non-Brahmins. This includes non-Brahmin Hindus, backward Hindus, scheduled castes, scheduled tribes, Anglo-Indians, Indian Christians, and Muslims. According to the communal GO, 2 out of every 14 seats are reserved for the Brahmins. This comes to 43 seats. Everyone else has to share the remaining 258 seats. So, there are 43 seats divided between 14,103 Brahmins and 258 seats divided among 3,43,34,386 others. This means that for every 32,560 Brahmins, there is 1 reserved medical seat. At the same time, there is 1 medical seat for every 1,33,079 non-Brahmins. The communal GO has allocated 14.28% of medical seats to Brahmins who make up 3.9% of the population of the state. This is more than 3.5 times, 3.66 times to be precise, of their share of the population. The point is that if the communal GO of the government was to be opposed, the basis for this would have to be that it was unjust to the non-Brahmin community. Champakam Durarajan claims that she would not be admitted to the college because of her birth into a community, when in fact the resources of the state are allocated to her community in a proportion much greater than their share of the population. She makes the statement with the assumption that the marks she scored would give her a medical seat in an unreserved entrance examination had she applied. She takes it for granted that the seats should be given to those who can score highest in an entrance examination. The Advocate General had plainly stated what would happen if the marks scored were the only consideration in his arguments before the High Court. If the mark standard were to be applied uniformly, the result would be, he stated, that while 249 Brahmin candidates would secure admission, no Harijan and only 3 Muslims would be selected. The fundamental question is that when there are only 330 medical seats available, are the resources of the state to be given only to those who have the capacity to utilize it to the greatest extent, or distributed equally among all the people in the state? Especially considering that the inequality in ability has been established through centuries of discrimination and would only be reinforced by providing more resources to the already privileged. There is also the fact that the marks do not measure the range of qualification that matter to the medical profession. Marks do not measure dexterity, the ability to handle stress, or compassion, which are necessary in the medical profession. While it is not possible to measure these qualities in an entrance examination, it has to be noted that the measures of merit that we use now are in no way indicative of actual skill. To argue that reservation erodes merit is an argument that has no ground, as we have no reliable way to measure merit. We only set up entrance examinations that provide added advantages to those who have the privilege of being trained for them. 70 years later, and we haven't learned enough from 1951. The National Eligibility and Entrance Test is the newest pillar that has been erected to hold up privilege. The public policy underlying medical education must be to distribute the resources of the state in a way that benefits all of the citizens, not just the ones who fit into the fictional ideal that the central government envisions. The entrance test is strongly biased to favor urban Hindi-speaking students graduating school from a central board of education. The NEET does a number of things. It worsens the already skewed urban-rural divide in the density of doctors. There simply aren't enough doctors to provide quality healthcare in our vast rural area, and it makes it worse. It prevents state board students and those who are less privileged from having a fair shot at getting a medical education. By predominantly favoring urban students trained by specialized coaching centers who invariably seek a high-paying job, this raises the cost of healthcare. One of the more blatant things that it does is the removal of OBC reservations for the All India quota seats. This takes 15% of the undergraduate seats and 50% of postgraduate seats from medical colleges maintained by the funding of the states and gives them away to the privileged class. This is entirely antithetical to the socialistic ideals of the country and is anti-national. It is the duty of every upstanding citizen to oppose this injustice.